The title of this lecture is Introduction to Criminal Law. We're going to sort of talk about some of the sources of law, types of law, etc. I apologize, this will be fairly long compared to the number of slides. Um, but again, do read the lecture notes as that's important as well. I will try to keep this briefer than the lecture notes. I want to just start with the mea culpa. I'm no expert. I'm not an attorney, so I don't know as much as an attorney. But I just want to let you know that in terms of crime, um, if there's no law prohibiting it, it's not a criminal act. Okay, so sometimes we forget that the criminal law changes over time in response to how um, society feels. So, for example, um, you might not have known that cocaine, heroin, opiates, etc., were not illegal until 1914, right? Um, you might not be aware, you may be aware that marijuana is currently illegal in most states, but now, recently, it's been made legal for medicinal purposes and also even in some states for recreational purposes, right? So the law changes, right? Um, so we're going to kind of look at how laws are formed and the types of laws and the bases of the United States type of law system. Um, as we start to get into this, it's important to realize that laws are sort of the having laws and being able to enforce them fairly um, is really the basis of modern democracies and economies. Um, it's the laws, if you think about it, it's really an extension of the idea of rules, right? And there are certain rules that are so important, we write them down in terms of make violating those rules crimes. Okay, but our free market system is absolutely, utterly dependent upon the government being able to enforce laws. Um, this refers to what's called civil laws, we'll find later, but um, essentially, um, laws are socially constructed by our legislators. Okay, and so you have the written law, which is law in the books, right? That's statutory law. Okay, and you see a definition there, so I won't read it to you. Okay, but that is created by legislators, right? So most criminal laws, if we're thinking about, it doesn't have to, as you'll see, this statutory laws can be things other than criminal law. But nothing, laws are created by our legislators. So if we thought of criminal law, the vast majority of street crimes that you can think of, murder, rape, robbery, etc., are what are called state crimes. So the state of Hawaii has written down laws that were created by our state senators and our state representatives, right? And then signed into law by the governor. Okay. So those are laws that are created by a legislative body in the government, right? Um, case law is sort of how do the courts interpret the laws. Primarily refers to judicial I'm sorry, I'm fumbling my words. Judicial precedent. So it's sort of like historically built upon cases. And so once something has become a precedent has been set by a higher court, it's supposed to be followed theoretically um, over time. Okay, but just to give you an idea that sort of these laws are what regulate judicial interpretations when you try a court, right? What's a legal arrest, right? You may have um, seen the movie where they read you the Miranda rights. You have the right to remain silent. Anything you can and will be used against you. You have the right to an attorney. That was from a case that was actually within my lifetime. So like sometime in the 60s or 70s is when that was created, right? And so that was a decision made by the courts. It was Miranda versus, I don't know if it was Arizona or something like that. But the idea was that the courts interpreted a legal arrest from here on out. In order to have a legal arrest, a suspect must be advised of those rights before they are questioned, right? Or the arrest is not legal. Okay, so that's an example of case law. Um, the other idea of case law is the idea of cruel and unusual punishment, right? Like some people think that there's this one famous case that I talk about in the death penalty um, called Furman versus Georgia. And it ruled for a time that the death penalty, the act of executing somebody, was cruel and unusual punishment just because all the different states had wildly different definitions of murder. And you could be put to death for rape in one, but not in another state, right? And they said that's cruel and unusual. But they did not say that the act of execution in and of itself is cruel and unusual. What they told the states is you need to go back and develop a set of definitions for what are heinous crimes. So you can only use the death penalty for what are called heinous crimes. And then all 50 states had to define that. And that came from judicial precedent. Okay. It's kind of like determining the rules of the game as you pass through the criminal justice system, right? How do we legally try somebody? What's admissible evidence, etc. Okay. But you also may have heard of something called Brown versus Board of Education. That's the law that outlawed segregated, separate but equal, right, in terms of education, right? So the idea, since that case, which was decided by the Supreme Court, states could not enact laws where they had so-called separate but equal educational systems where black kids went to one school and white kids went to another. Okay. There was a judicial precedent case that has scared the living Jesus out of Kamehameha schools. There was this dude, I don't know if you guys are old enough to remember when OHA, the Office of Hawaiian Affairs elections, were only available to people of Hawaiian descent to vote on. And I personally agreed with it because it had to do with using monies that were on Hawaiian lands that were taken from the state and they were supposed to pay them certain royalties on it. That's just my personal opinion. You don't need to agree with me. But this one rancher on the Big Island, it was Rice versus Cayetano. Cayetano was the governor. And so there was this conservative Supreme Court at the time, and they took it and they said, hey, this is on the basis of race. And so using different laws, they said this should be illegal to have only Hawaiians vote in this. So the courts agreed with Rice and overturned Cayetano, and so now anybody can vote in OHA elections in the state of Hawaii. The reason why it scared Kamehameha was that Kamehameha was so Bishop Estate, right? She was such a cool princess. She set up, so basically Punahou was the first school, right? But they wouldn't let Hawaiian kids in Punahou, right? So the queen, I think this is cool. You don't need to agree with me. She said, okay, you want to let my kids in? Watch this. So she made her own school, right? And it was made for Hawaiian kids. And so it's traditionally been a school for Hawaiian kids, right? But since Rice v. Cayetano, they are settling cases out of court because they were afraid that if that went to court, it would be seen as a race-based law and they wouldn't be allowed to have basically the Hawaiian preference for admission to Kamehameha schools. So I don't know exactly how they get around that. I think they call it a preference as opposed to a requirement. But the point is that like there was this one kid, I think he was Hanai adopted by a Hawaiian family, but he wasn't Hawaiian blood. He's from Kauai and he went to Kamehameha. They tried to kick him out. And so once Rice v. Cayetano went down, they were worried that it wouldn't stand Supreme Court scrutiny, case law scrutiny, and so they settled. And so at this point, that's why Kamehameha Schools is not going to allow anything like that to go to the Supreme Court. They're going to settle out of court. All right. So remember, statute law, law in the books. Case law, how judges have interpreted the laws on the books. Think of it as the rules of processing, if you will, in a way. Okay, development of the United States law. There's a couple of historical laws over time. I shouldn't say laws. Things in history that have brought us to where we are with the United States law. Okay, the first thing is I can't even say that, the Code of Hammurabi. I don't know what that is. Okay, but it was one of the earliest known written forms of law in the West. Okay, I like this because there's a reggae reference. King Haramabai, or whatever his name, he was the king of the ancient city of Babylon. Okay, and they had some laws on stone tablets that regulated property rights and other sorts of stuff. Okay, it was thought that one of its primary purposes was to keep the city, Babylon, a center of commerce. But it's important because it was written down, it made punishments regular or consistent and predictable. Okay, Roman law also came from stone tablets, apparently. Guess they didn't have paper like the Chinese back then. Um, they basically regulated aspects of life, right? And the importance here was Roman law made a distinction between public and private law. So private law relates to businesses and property. Back then it included humans, slaves, right? And so that was said to be the foundation of civil law. If you'll see in a moment, what we have are criminal law, which relates to crimes against society, and then what's called civil law, which is viewed as private disputes. So, for example, if you slip in the supermarket and want to sue Safeway, you do not sue them under, it's not a crime because you fell down, right? You sue them under civil law, which is a private dispute between you and Safeway. So any of those things, like when you see where they're advertising for people from the Honolulu shipyard who might have been exposed to that one chemical or whatnot, attorneys, right? Or they'll be advertising if you took a certain drug, right? They'll try to get you to sign on to a lawsuit. That's under civil law, okay? So think of those as laws that regulate business and commerce and stuff like that. Okay, we'll get into it in more detail. Okay, so again, Roman law distinguishing between public, we would call that criminal, and private law, we call that civil. Okay. Common law, this refers to English common law. Okay. It refers to laws that came about via tradition rather than written statutes, rather than written down. Okay, and they developed sort of out of a series of judicial decisions, right? And as I say in the lecture, I have a quote. It's based upon non-statutory, that means non-written down law, customs, traditions, and precedents that help guide judicial decision making. I'm having a hard time with that word. I apologize. So it's common law has largely been replaced by statutory law. Common law still plays a role in judicial interpretation. Okay, you can kind of think of it as when we start to study judicial decisions, right? That's the idea that we talked about on the previous slide, right? Okay, the Magna Carta, I think that is literally the Great Charter. It's said to be the foundation of many of our present liberties. Okay, it was written apparently as a set of concessions, but it was later interpreted to give sort of a Bill of Rights, certain liberties to the Brits. And we see that in what we call the Bill of Rights in our Constitution. There are certain rights that you have as an American citizen, right, that cannot be taken away from the government. Okay. It also provided a provision that unjust laws passed by legislators could be made void. Some say that's the basis of our Supreme Court. So remember I talked about Brown v. Board of Education. One of the places in the South wrote a law that said we're going to separate the races, but they're going to be separate but equal educational facilities. Right? That was legal in that state, but then it got taken to the U.S. Supreme Court, which trumps state law. So federal law trumps state law when there's a dispute, because based upon basic certain rights, right? And so that was struck down. Okay, so that's the idea of the Supreme Court and this idea, okay, that laws can be made void. Okay, the United States Constitution, that is the basis or the foundation of all law in the U.S., okay? It is the final authority in all questions related to law, rights, etc., power to the federal government, all that kind of stuff. Okay. The Constitution itself does not contain many specific prohibitions of behavior, but it is the final arbiter, which the Supreme Court and the other courts look at to determine whether a law that was written by legislators meet the guidelines, fit into the spirit of the rights guaranteed by the Constitution. Okay? So it's basically saying whether existing laws are acceptable according to the ideals of our Constitution. Okay, natural law is just a notion, okay? This is the idea that criminal laws are seen as they're based upon some sort of unassailable absolute moral principles that are said to be part of the natural order of things. That's how they get the law. Excuse me, the name natural law. Okay, these laws are said to be knowable via some sort of revelation, intuition, reason, or even prophecy. Okay, as you might imagine, it is tremendously intertwined with religious concepts. In the West, it would be primarily Christianity, right? Okay, these two Latin terms, isn't the last bullet point, mala and se and mala and prohibita? I'm saying that like my Spanish because I can speak a little Spanish. I'm sure that's how you not say it. I don't know how Latin is pronounced. Okay, so there are two kinds of laws. There are two notions that apply to law. Mala and se is the idea that some things are simply wrong in and of themselves. They are crimes against humanity, if you will, such as murder, rape, stealing, etc. Back then, they would have said certain forms of what they called sexual deviance. And by deviance, that doesn't mean bad. Okay, deviance just means different from the norm, right? If you like to dress with a nose ring, right? It's deviant in the sense that most folk don't do it. Okay, not that it's right or wrong. Don't get that confused. Okay. So they were sort of saying that these mala and se were the formation or where these violations of natural law came from, right? Now, violations that are only wrong because there's a law against them are the other one, mala prohibita, right? So I like to think of prohibited, right? That's how that helps me. It's only prohibited because there's a law. Okay, this includes the moral offenses such as prostitution, gambling, illicit drug use, etc. Right? The only reason that marijuana is illegal in Hawaii and getting high on alcohol is not is because of a law prohibiting marijuana, right? And other states have changed that, right? So they're saying that making this distinction sort of helped create distinctions in punishments and the sentences that were held out under English law, English common law. And you'll see how that plays out where we make a distinction in our criminal laws in terms of the punishments. Okay, now I want to talk about the rule of law. The rule of law is very important because it's credited with providing social, economic, and political stability to a country. Okay? I won't read you the quote, but you can see it. But it's central to the idea that no one is above the law. Okay? I'm re-recording this lecture in January of 2021, right after. Look, I don't care about what you think about Republican principles, meaning their philosophies or democratic principles. Okay? That's separate. Okay? But the fact of the matter, there are facts in this world. Okay? And the fact of the matter is that there is no credible evidence that there was enough voter illegalities to overturn when Trump lost the election to Biden. That's why it was thrown out by over 60 courts. Okay? But what Trump tried to do is use extra legal. He tried to go outside of the rule of law when he asked Vice President Pence to not certify the Electoral College. That's when that was when the certification by Congress of the Electoral College, that's when that big riot happened and people stormed the Capitol. Not all, but some, right? And the way the law was written, Pence did not have the ability to not certify the elections. He was supposed to open the envelopes and count them. That's all that the Constitution allowed. Trump was trying to get him, whether you like this fact or not, it's a fact. Okay, I don't care whether you like Trump or you don't like Trump. I'm talking about law and facts about law. Um, you can like Trump's policies, but still agree to this fact, I guess is what I'm trying to say. Is that asking Pence to go outside of the law would have been against the rule of law. So the fact that they went ahead and did not do that was a triumph of what's called the rule of law. Okay. Why is that important? Okay, it's especially important. So that's a form of political stability, right? That we had a peaceful transfer of power. Okay. It's important for a stable, sustainable business environment. Okay. So, for example, many Western countries, or companies, I should say, are very, very, very reluctant to invest in Russia. Okay, Russia has huge oil resources. Okay, but one of the reasons why American investors don't want to invest in Russia, I'm not saying all, but why they're reluctant, is because they know if there's a legal dispute over the money, it's not going to be decided by the rule of law by judges using like it would in the United States or other parts of the West, like Europe, etc. Okay? It could be decided just if their current dictator, Putin, or his cronies don't want to respect it, they won't, and you'll lose your money. Okay? Another way where you see this is, I don't know if you've heard about this, but a lot of rich Russians and rich Chinese people are afraid to leave their money in what are called liquid assets. Think of a bank account or stocks and bonds or something, because the government, because there's not a strong, weak rule of law there. If somebody in the government decides you're a bad person, they don't have to take you to court and take your stuff away. They could, but the courts are seen as not being legitimate. They don't have a legitimate rule of law. It's ruled by a personality. So they could just basically get some, so judges there and whatnot are not as powerful like they are in the United States, where we have co-equal branches, right? So basically, they could just take your money if it's in a bank account, stocks, or whatever, right? So what they've begun to do is buy real estate in London. At certain points, it was in Hong Kong for a while, and then parts of Canada, right? For example, in Western Canada, there's this town called Vancouver where their local real estate. I've been going skiing there for several years at spring break, and I've seen how they're basically tearing down residential neighborhoods and building big apartment buildings because real estate is so very expensive. And that's because a lot of these people in London, and in this case, same happened in London, and I'm sure it's happened in other U.S. cities as well, right? A lot of what are called Russian oligarchs have bought a lot of real Trump properties and other properties in the U.S., right? And so when you have more people buying real estate, that drives up the price, okay? And so, number one, why do they buy it here? Because we have the rule of law, okay? If you bought a big home in China, the government, or Russia, the governments could just take it away from you, right? Secondly, in the U.S. and Canada and London and Europe, they can't just do that because we have strong rule of law. Lastly, real estate is an illiquid asset, right? It's hard for the government to take away your house in another country, right? If you had stocks and bonds in the U.S. and you tried to move it to your home country to use it, then they could take it, right? Because it's what's known as a liquid asset, right? So that's sort of an example of why these oligarchs in China and Russia and elsewhere buy real estate in the West, is because we are a nation of laws, right? And your investments and your property cannot be taken from you at the whim of a dictator. You have the protection of courts, right? That's why people are reluctant to go into certain countries and invest if they're run not by a rule of law, but by the whim of dictators, right? Your investment can be taken away from you. You have no legal real recourse, and if you do have legal recourse, it's known as being a sham and not a real court, right? Okay, so you can read, I say this a bit more eloquently in the written portion of the lecture. Okay, I want to talk about the types of law. First, there's criminal law. Think of this are the things that you're probably most familiar with: murder, rape, etc., right? They're deemed crimes because they're thought to be crimes against the fabric of society. So we punish you for stealing someone's car if you're caught stealing someone's car, not because you hurt that one person, but you injure the fabric of society by doing that. If you murder somebody, it's not just because you hurt one person, it's you injure the fabric of society, if you will. Okay? That's why the state actually is like when they accuse somebody of being a crime, it's usually the state of Hawaii versus, and then they name the person. Okay, there's two kinds of criminal law. You have the substantive criminal law. Think of that as the written law that is written by the legislatures. Okay, they sort of define what murder in the first degree is, what the punishments would be, what any mitigating circumstances, stuff like that, right? Procedural law is sort of the body of rules that regulate processing through the criminal justice system. Think of it as the rules of engagement for the sort of legal, it's called, I can never say this correctly, adjudication. Okay, so how do you legally think of justice, right? How do you legally apply justice to somebody throughout the legal system, right? So, like when you ever see the thing about whether or not it's a legal arrest or in a courtroom, stuff like that, right? Like they'll argue, well, they violated procedures, right? Miranda rights are an example. You may have seen, I believe it was Miranda versus Arizona. You may have seen that on the movies and the TV where they go, you have the right to remain silent, everything you want to. Okay, so the Miranda decision, I believe, don't quote me, but I think it was Miranda v. Arizona. And it determined in order to have a legal arrest, you must read these rights to somebody prior to questioning. It's called, and I think it technically is like prior to what they call custody, right? So basically, you put them in custody and you read them that right? And then you can sort of take them in, if you will, right? So the idea is that it protects them from self-incrimination and informs them of their basic rights, okay? So there's all kinds of rules for a criminal court trial. There's rules about what's legal evidence, what's not, etc. Okay. Civil law, that's private law. Okay. It's rather than something that where it's a crime against society, it's deemed as a sort of a dispute between two private parties. Okay. Sometimes called a tort law because it's viewed, I guess it's a tort, right? Civil violation is called a tort, which is not a criminal act. Okay. But they can be persons, businesses, government agencies, other organizations, etc. Okay. So civil suits typically seek monetary damages or sometimes some other form of compensation, typically money, rather than punishment. Okay. They're interested in intent and not liability. Right. Sorry, they're not interested in intent, but liability. Right. So that's why, if you can long enough to remember, there's this really great running back. He was sort of very famous on commercials and stuff, named O.J. Simpson, and he was accused of killing his ex-wife and her boyfriend. He got off in the criminal trial, but the family sued him under civil law, where there's less of a burden of proof, and he owed them monetary damages. Okay, that was under civil law. There's another really interesting story. Is when I was a kid, there's this car. You can see that ugly car on the slide called the Ford Pinto. That had something about the gas tank would make the car explode or catch on fire when it was rear-ended. And what the Ford Company, what they should have done, all of us would argue, was recall the car and fixed it so people didn't die. But they made the decision that we'll just pay damages in civil courts because we'll end up paying less money in the long run if we do that rather than recalling the car. Okay, so they would say, well, we'll just go to civil court and they'll sue us and we'll settle out of court and that'll be that, right? Now, isn't that kind of funny that that's not really seen as entering the fabric of society, right? So anyway, remember, civil law is disputes between private parties, typically seeks monetary damages. Administrative law, think of these are sort of the rules that administer government. Sometimes industry, like EPA, environmental rules, etc. So tax laws, health code laws, pollution laws, vehicle registration, etc. Right? So if you are a public administration major, you can take a course called administrative law, and that talks about, so basically they're the laws that govern the functioning of governmental agencies, if you will. Okay. Case law refers to, it's the study of judicial precedent. That means the study of decisions made by courts in the past. It's not written down. It's not the written down law. It's more the study of past decisions and what courts have decided. Now they write that down. The court, like the Supreme Court, will make a decision and they'll actually write their decision, right? But it's different from the legislatures passing a law. Okay, it's the courts interpreting already written laws. Okay. Stare decisis is important. It literally means standard by decided matters, I guess in Latin. And it's the idea that courts must be consistent with past decisions and also higher courts over time, right? Sort of what is thought to create consistency and predictability in the law. There's two types, horizontal and vertical. Okay, one is that courts on one level are bound by decisions of the past on that same level. Okay, so that's horizontal, right? So if you're, in a district court, you need to decide as other district courts have decided on this particular thing in the past, right? Horizontal, think hierarchy, right? It refers to up and down agreement in the court system. For example, everything is under the Supreme Court, right? So if the Supreme Court says something, every court below it needs to say that's how they're going to decide. So for example, Brown versus Board of Education was a suit where I don't know which state it was in the South, right? But they wrote a law called separate but equal. Basically, black kids and white kids it's okay to have separate schools, but they're going to have separate, but they're going to have equal facilities. So somebody in Alabama, I don't know where it was. I apologize if it wasn't Alabama. I don't know where it was. Mississippi, something like that. They sued. And what the Supreme Court ruled was that separate but equal is no longer legal. So that was relevant now to all courts in the land because it's the U.S. Supreme Court, right? So it would mean other states, not just whatever state brought that court, right? So somebody brought that case against state law somewhere, right? I'm just going to say pretend it was Mississippi, okay? But when the Supreme Court made that decision, it was applicable to other courts in other jurisdictions, not just Mississippi. Okay. There is an inherent bias between the legal system and the social sciences and stare decisis. This is sort of interesting. I got this from one of my professors who, I don't know if you've heard of the Stanford Prison Experiment, Haney, Banks, and Zimbardo. Craig Haney was a wonderful professor of mine as an undergrad. And he kind of said, so Brown boards of education actually used some social science to help it guide its decision. And he said, there's kind of an inherent conflict between the social sciences and science in general in the legal system. Sort of the legal system, as I've just explained, is bound by tradition, by authority in the past. There's a resistance to change, right? The actors in the legal system, when you go before the Supreme Court, you don't just say, hey, this is wrong, Judge. You say, in Brown versus Education, this court ruled blah, blah, blah. This is why, this is how it applies to my case, and you need to rule consistent with Brown in this matter, Your Honor. So that's the idea that they're made to think and argue within a body of already decided matters. Okay, so you fit your argument within what's already occurred. Science and social scientists, however, are encouraged to do the opposite, to be creative outside of the box, think of things that have never been invented. To press the envelope. So it's one of the reasons why it's difficult to integrate social science in the legal system. Sort of different actors in each system are rewarded for different things. So it's just kind of a way to kind of conceptualize two different ways of knowing, if you will. I want to give you an example of stare decisis in the real world. Sometimes we see Latin, right, and it's such an esoteric concept. We have no idea how that applies to our lives or how it exists in the world. And so, if you spent time in Hawaii, I'm going to talk. Well, you will have heard of Office of Hawaiian Affairs and command mass schools and whatever. Okay, so this is an example of how it's affected Hawaii. Okay, um, I want to start with a caveat about morals and pushy professors. I hated it when professors wanted me to have. They basically tried to get me to have their moral views of the world. I think there's a difference between morals and facts, right? So there are facts. I didn't have a problem when a professor told me facts, right? But when they wanted me how to think about those facts is a moral decision, right? And so I never wanted to be one of those professors. I want to present you with facts, and then how you decide is fine. Now the other part about that is I have moral views, and my moral views are fine too, right? I'm going to express some views based upon facts, and you don't have to agree with them, but that doesn't mean my moral view is wrong either, right? So your moral view is okay with me. Flip side of that coin is you have to give me the same benefit, right? It's impossible to argue morals because there's no basis there's no facts which we can bring to bear to say, well, your view is my view. You should feel as I do, right? So there's this thing called Office of Hawaiian Affairs. There's a couple of facts. I don't know exactly how it was started, but I do know that the law was written where basically the state has got some lands that were traditionally Hawaiian lands or something, and they're supposed to use revenue. They get revenues from that land. They're supposed to use a portion of that to give to OHA, right? And then the trustees of OHA would decide how that money is spent to the benefit of Native Hawaiians. Okay, it's also a fact that the state has not been giving the amount that they were supposed to in the original law. Okay, so they're way behind their payments. Okay, now how you feel about that is your own business. My personal view is that's wrong. Okay, the law said you should be paying them this much money. You should be paying them that much money. Okay, but the other fact is that OHA trustees are the ones who decide how those funds are spent. Okay, so that's a powerful position. When I first came to Hawaii, only people of Hawaiian descent could vote for this agency. Okay, that's a fact. How you feel about that's a different is our morals. Me morally, I didn't have a problem with that. It's supposed to benefit Native Hawaiians. I wanted Hawaiians to be ahead of that agent and decide how it's going to be spent. Right. In fact, I was fortunate enough to be hanai'd by a Hawaiian family in Waianae, which is where I live in Makaha. Let me tell you, they got serious issues with OHA and command mass schools. And so Granny, all of her kids, my auntie boy, all of her kids, Uncle Moku, all of them, pure Hawaiian. Not one of them got in. Okay? So don't get me wrong here. I'm critical of them, but maybe in different ways than some people. Okay, so this rancher from Hawaii, he must have been non-Hawaiian because otherwise he wouldn't have what's called standing to sue. So basically, this is key, with the help of some very right-leaning organizations, they funded the suit to sue and use civil rights law to argue that Rice's civil rights were being violated because only Hawaiians could vote. Now, here's also a fact, whether you like it or not. Civil rights law was passed because to benefit less socially powerful folks from the more powerful majority. In the case of civil rights law in the 60s, it was designed, obviously at that time was primarily African Americans in the South, right? There was stuff like separate but equal and Jim Crow laws and whatnot, and they overthrew that, right? So it was designed to right a wrong, if you will, and to make policies that continue systematic racism like that illegal. Okay, and then Rice, this is also a fact whether you like it or not. Over time, what's happened is Native Hawaiians are at the bottom of the socioeconomic status. More disease, more poverty, less health, less social power, et cetera, et cetera, et cetera. Okay? So if you think about, now what you think about that's your view, okay? But in my personal moral view, well, OHA should be there to remedy that, right? That's what civil rights law was about. Long story short, Supreme Court doesn't agree with my moral view, right? That's what a lot of these decisions are about. When you interpret the Constitution, there's obviously it's a moral decision, and they said, well, they were a conservative Supreme Court. They agreed with these conservative think tanks, and they said Rice's um, civil rights are being violated. Many people disagreed with that view, saying that's a twisting of civil rights law. That's using it for the more powerful. This guy was a Hawaii rancher, right? Which probably means he was pretty wealthy. Um, anyway, long story short, regardless of that, point is that this new law now said anybody can vote in OHA elections to elect the trustees who will spend this money. And that's the case now. So anybody can vote. I personally don't vote because I am aware of that history, and I just am morally opposed to voting. I don't think it's right. But if you do, that's fine. I don't. That's cool. I'm not here to tell you how to think morally. Okay. Now here's where it gets important. Stare decisis affected Kamehameha schools, and it affects the way that they are dealing with opposition to their Hawaiian, basically it being a school for Native Hawaiians. Okay, so my understanding of Hawaiian history, you guys can correct me if I'm wrong, and please do on all of this, and I will gladly change this slide. But when the Haole missionaries came, they set up this school called Punahou. It's a private school. It's very, very, very influential. Still very expensive. Still very, very, very prestigious. But back in the day, in the 1800s, they said, guess what? Hawaiian kids can't go. Only Haole kids can go. Now, what you think about that is your business. I personally think that's bullcrap, but I love how this princess dealt with it. She was wealthy, and I think it was the Bishop of State. I think that was her, but I'm not sure. But basically, the story is cool. She said, "Oh, okay, watch this." So she made her own set of schools, and only Hawaiian kids can go there. So it's kind of like, oh, you won't let my Hawaiian children? She viewed them, she was the queen or the princess, so she viewed them as her subjects, if you will. And so she was supposed to take care of them, and she made a school. And I think that's cool. Now, again, I'm not saying Kamehameha Schools is a perfect institution. I have my issues with them. But that's how it came about, right? So at some point, there was a kid. I might get these facts wrong, but I know he wasn't Hawaiian. Okay, I believe he was a kid from Kauai who was hanai by a Hawaiian family. He was already in the school, and then they found out he was there. And there's a big brouhaha about whether he should be kicked out. I do know that this was after Rice v. Cayetano, and the school was rightly concerned that if this ever went to court, their admissions policy would be struck down, that they wouldn't be allowed to give preference to Native Hawaiians. So I think that somebody please correct me, I think it was, originally you had to be Hawaiian, right? Since Rice v. Cayetano, I think they changed it to Hawaiian preference because that is actually legal. The Supreme Court, even recently, has said that colleges may use race as one criteria to admission to college because it's about creating a diverse student body, which is better for the educational environment of a college. Okay, it hasn't been applied to private schools which are below K through 12, is my understanding. I could be wrong, okay, but I believe that's the case. So if you were a lawyer, right? Lawyers, it's kind of weird. Like the first thing you learn in law school is they take a case and they say, write a paper arguing both sides, because a lawyer is supposed to defend their client no matter what, right? It's not about, you could decide whether or not to take your client, but if you do that, you're sort of not going to have many clients, right? And the idea is that an adversarial legal system requires that you fight as hard as you can for your client, regardless of whether you think they're guilty, wrong, whatever, blah, blah, blah. That's just the way it's set up, right? So if you were somebody who wanted to argue against that school, you would use the prior case, stare decisis. Courts need to stand by already decided matters, right? You would go to the Supreme Court, you would argue, look, you must rule consistent with Rice v. Cayetano. And you then must strike down Kamehameha School's Native Hawaiian preference, because that is illegal under civil rights law. That's what you would argue, right? And that's what Kamehameha Schools was afraid of, and that's why they, at least, I don't know if they still do that, but I'm pretty sure any kid can apply now, and they just say it's Hawaiian preference, right? And they don't want to go to the Supreme Court with a conservative majority. It's even more of a conservative majority now than Rice v. Cayetano. Right, so that's an example how stare decisis, at least in the past, affected Kamehameha Schools and their behavior in terms of their admission policy. I believe it's still in effect. Correct me if I'm wrong. So again, don't get caught up in what you feel about Hawaiians, non-Hawaiians, whatever. Don't get caught up in race. Race is a very, very sensitive issue for many Americans. I'm using it as an example of stare decisis in the real world. I am not using it as an example for tell you how to think morally about civil rights, about Hawaiians, about social power, whatever. That's your business. I've given you my views. Mine are few, fine, but I'm not going to argue yours. Okay, yours are fine, in my opinion, as well. But it's an example based upon some facts of how stare decisis has affected the world. All right. That's the end of this slide. Okay, we're going to talk about some of the types of criminal violations. An offense is the least serious type. Think of that as a traffic ticket, jaywalking. I don't know if this is still true. It used to be like spitting on the sidewalk. Okay. A misdemeanor, there are various kinds, but we'll just keep it simple. A misdemeanor is a relatively minor criminal offense. They can't result in arrest unless the police officer catches them in the act, I guess. An arrest warrant can be done in the future, though. Okay, but examples might be petty theft, simple assault, disturbing the peace, possession of small amounts of certain drugs in some states, etc., drinking underage, etc. Okay, that doesn't necessarily apply to every single state, but I'm just kind of giving you an example. And you can see there that that's sort of the max is usually 6 months to a year. Once you get into over a year incarceration, you have what's called a felony. These are our most serious crimes. And we distinguish prison from jail in terms of if you're in prison, you're going to be there for a year or more. Jail is usually less than a year, theoretically speaking. Okay. So once you get convicted of a felony, now you can go to prison. Okay. So the major, they can differ through states, right? But generally they will, most of the states and jurisdictions will have, rape, murder, robbery, arson, aggravated assault, right? So it's the most serious kind of criminal offense, okay? Now, just because you're convicted of a felony doesn't mean you'll automatically spend a year in prison. It just means you might be eligible, okay? I do have a lecture where I talk about probation, where my mentor did a study of felony probation in Hawaii. Probation means you're convicted of a felony, but I put you on probation. You're not going to be locked up as long as you're a good little boy or girl and you follow these rules. Okay. I don't even know how to pronounce inchoate offense. Okay, but these are offenses that are not yet complete or carried out. Think of the mafia conspiracy type or conspiracy to commit murder. When they were looking at the Capitol, some people who went into the Capitol in January 6, 2021, they say they were conspiring to overthrow the government, right? That would be an idea of it. So they didn't do it, but they were planning on doing it. They were conspiring to do it. And treason, that's the idea of you're trying to overthrow. It's you're basically disloyal to your country and you're trying to overthrow it. Okay? And you can read the lecture for that. Okay, in order to be guilty of a crime, you have to have these two things occur at the same time. Okay? It's called concurrence. If they don't both occur, you're not guilty of a crime. So first, actus rea, it's a guilty act. So I look at actus and I think act, right? So there must have been a criminal act committed by somebody, right? They may have done something, so you have to be convicted of doing the act. And then you also have to have mens rea. Mens, I think of mind, right? Mental, right? Mental speaks to your mind. You have to have a guilty mind. There are many kinds, but you have to have a culpable state of mind, right? It's not the same as motive, okay? But the idea is like there might be different kinds of murders, right? And they're based upon what is your state of mental culpability, right? So, for example, murder in the first degree requires planning, right? So, not only did you know what you were doing when you committed it, but you planned it ahead of time, right? So, there's other kinds of homicides where it's not that sort of like the idea. Don't quote me on the legal exactities, but the difference between murder and what's called, what is that called, manslaughter, is the idea of the mental status, right? So I think if you ran somebody with your car, right, but you didn't mean to do it, but you still killed them anyway, you had less mental culpability because you didn't intend to do it, so you're not guilty of murder, you're guilty of what's called manslaughter, okay? If you've ever heard of the insanity offense, right, it's the idea that you may have committed the crime, but you were incapable of recognizing that it was wrong when you did it. It's actually contrary to what you hear on sound bites and stupid commentators and what you see in the movies. It's a really hard legal defense to prove. So it's not used very often. Okay. Um, Let me talk about strict liability and mens rea just for a moment. Okay, I want you can read through some of the other examples in the lecture. But there are some offenses that have strict liability and don't require mens rea. It's the idea that some offenses cause harm regardless of your state of mind. Sometimes, like statutory rape, which is the rape of somebody who's too young, having sex with somebody who's below a certain age, or certain traffic exempt things. It's like you didn't have to intend to go speed, but you sped, and so you're guilty of it, right? You don't have to have meant to do it. Same with like having sex, even if it's consensual, right? If you have sex with somebody, different states decide what is too young for an adult to have sex with. I don't know what it is in Hawaii, right? But like in some states, it's legal if they're 16 or older, right? So let's pretend you have sex with somebody who's younger than that. Even if you didn't know they were younger than that, you're still guilty, right? That's what it means. Okay. Um, for Public Administration 409, you will not be tested on the next section of a critical examination of criminal law. Okay, so you don't need to worry about that. All right, that's the end of the lecture again. I warned you it would be long.